We are privileged to welcome Ms. Begum, an international arbitrator, technological entrepreneur, and a leading voice at the intersection of law and artificial intelligence. She currently serves as CEO of Business Soft and iCloud, pioneering digital transformation and legal tech innovation across Central Asia. Ms. Begum holds appointments as an arbitrator with several prestigious institutions, including LCIA, SEC Arbitration Institute, and arbitration courts across Central Asia. Her multifaceted expertise in ADR, technology, and cross-border dispute resolution makes her a truly global thought leader. We invite Ms. Begum to share her insights on the ADR landscape in Kyrgyzstan and enrich today's discussions. I now hand over the floor to you, ma'am.
Dear ladies and gentlemen, thank you for the kind invitation. It's a pleasure and honor for me to take part in this insightful event, and I specialize in the intersection of law and technology with a focus on legal tech, cybersecurity, and ethical AI. Implementation in alternative dispute resolution. Today, I will be sharing my perspective on a vital and timely topic, data privacy and cybersecurity in AI-driven ADR. As we automate dispute resolution processes and increasingly rely on AI, we must remember that data is the new currency, and with data comes great responsibility. Why data privacy and cybersecurity matter in AI ADR? Nowadays, ADR inherently involves sensitive data. This includes confidential contracts, trade secrets, and communications between parties, and even personal data. AI systems
I'm extremely sorry to disturb in between, ma'am, but if in case you are presenting your slides, I just wanted to inform that the same is not visible. It's just the taskbar that is being visible, like the 10 slides. The slide that you're presenting is not visible. If you want, we would be more than happy to facilitate it from our end, where we could, present it for you.
Could you please repeat? Is it for me?
Yes, ma'am, it is for you, ma'am. If in case you are presenting your slide, sharing your screen, the slide that you're currently presenting is not visible. It's just the taskbar that's visible, ma'am.
Okay.
We would be more than happy to facilitate it from our end by sharing the screen from our end.
Okay. And maybe later I will resend my presentation.
Sure. No, ma'am, it's already there with us.
Okay. And AI systems are now used to process this information, analyze contracts, extract patterns, draft predictions, and where is this data stored? Often it is stored in the cloud or on external platforms, sometimes managed by third-party providers. And this creates risks. What if the data is hacked, leaked, or misused? And let me illustrate with a few examples. In 2023, a data breach affecting the ODR platform used by multiple chambers of commerce in Asia exposed confidential records from over 200 arbitration proceedings. This incident raised urgent questions on accountability and vendor trust. In China, a cloud-based arbitration court used AI to process legacy case files. AI models were trained to read and anonymize documents, cutting human workload by 90%. However, this demanded very strict controls on data access and anonymization. And also GEMS, a global dispute resolution provider, introduced specific arbitration rules for AI-related disputes, including provisions for protecting sensitive data via expert supervised review. And Columbia Law's Arbitration Journal analyzed how AI-driven tools in arbitration are capable of legal prediction and document automation, and yet require strong ethical standards to ensure data security. We've already seen examples of deepfake technologies being used to spread disinformation. The legal field is not immune to such risks, especially when AI is integrated without safeguards. And about another side, legal and ethical uncertainties. The reality is that there are currently no unified global standards for protecting data in AI-based ADR platforms. This creates ambiguity, particularly in cross-border disputes where legal systems differ. And what about liability? Who is liable if there is a breach? Arbitrator, AI developer, or platform provider? And without clear regulation and ethical guidelines, we risk exposing sensitive legal processes to serious vulnerabilities. And we must also understand that many AI tools built on data sets that are opaque and difficult to audit. And when platforms host sensitive information without clear governance, the door is open to cyber attacks or regulatory violations. And another concern is the use of public data or surveillance-based data sets in AI training, which can be resulted in the unintended bias or discrimination during automated arbitration steps. And ethical frameworks such as the European Union's General Data Protection Regulation and emerging acts like the European Union AI Act are beginning to address this, but adoption is uneven. Practical recommendations from my side are that so what we can do. I share 5 practical and actionable steps. First, conduct thorough risk assessments before implementing any AI solution in ADR and understand who handles the data, what data is involved, and how it is processed. And ensure encryption and data integrity by using end-to-end encrypted channels for communications and cloud storage, especially during online hearings. And also adopt ethical and legal AI models and also require transparency and oversight for high-risk models. This approach is recommended on the procedure. Apply the principle of data minimization. Only collect data that is necessary for the dispute. Avoid over-reliance on biometric location-based identifiers. Engage dedicated cybersecurity advisors or officers to review platforms and workflows in AI-assisted arbitration. And looking ahead, what institutions can do. Nowadays, international arbitration institutions like SIAC, ICC, and VIAC are now reviewing their protocols to integrate AI ethics and cybersecurity clauses. As members of the global ADR community, we should advocate for regional cooperation and the development of shared audit standards for AI in dispute resolution. Respecting data means respecting trust, and in ADR, trust is everything. AI may improve efficiency, but it should never replace human judgment or ethical oversight. And I think that be proactive, conduct compliance checks on the tools and platforms you use. Never outsource decisions blindly to algorithms, especially without transparency. And to conclude, I believe that AI can help us solve disputes faster and more efficiently. But it is our duty to ensure that technology works for justice, not against it. We are not against new technologies. We are for responsible innovation. And as I'm a resident of the Central Asian Association for Artificial Intelligence, I would like to recommend use AI tools for daily works and to foster our working processes. But we should be more attentive and more responsible for using and working with different kinds of instruments for our workflow. Thank you for your attention. And I would like to share my best wishes, and thank you for invitation.
Thank you, Ms. Begum. It was a really wonderful insight on how AI is going to look into this particular ADR platform. At this juncture, on behalf of KFCRI, before sharing the thanks note, I wanted to just supplement what ma'am you have just mentioned about the very significant thing. AI should not replace, but AI is going to facilitate the dispute resolution.
Yes.
Yeah, that is very, very important point. Why I look upon is that coming from a country, Kyrgyzstan, it's a Central Asian country, as a information to many people, audience and practitioners. Historically, this particular country for a long period happened to be part of the Soviet Union. And it is now one among the CIS countries after the 1991 breakaway of the Soviet Union bloc. Kyrgyzstan, which is identified as Kyrgyz Republic, is one of the least studied in Central Asia. As a history student, many would be happy about Genghis Khan, who had a great time administering that particular region for a longer period, and his descendant also has just had the same say. But what is significant, in addition to the technological impact in Kyrgyzstan, particularly for ADR, which is across the globe on ODR, also online dispute resolution, we do have the prominent aspects of dealing with these disputes. As a supplement to Ms. Begum, what we can see is that one of the very interesting book about law and practice of international arbitration in the CIS region, it is somewhat wholly neglecting some countries while giving sufficient attentions to the other, the former Soviet republics, such as the very prominent one of Russia, Ukraine, Kazakhstan, and other states in Commonwealth independence. When you look on the Central Asia, beyond Kazakhstan, there are countries like Kyrgyzstan, Uzbekistan, Tajikistan, Turkmenistan, Azerbaijan, Armenia, Georgia. All these independent states are somehow happening to be neighbors contributing, particularly the arbitration arena. Here, the research done by KFCRI and the team found that the legal foundation of Kyrgyzstan, particularly the arbitration regime in Kyrgyzstan, has been literally inherited from the Soviet Union. The USSR arbitration, wherein as private dispute settlement mechanism, which was based on consent of the parties, which happened to be alternative to state judicial system, was limited. But still, when we look on the Soviet Union constitutional articles for Kyrgyz Soviet Socialist Republic in 1978, it guaranteed the citizens of Kyrgyz Republic to settle commercial disputes between enterprises institutions as well as organization, but through state-run arbitration courts. The arbitration institutions were identified as arbitration courts, and all these arbitration courts were operated by the sovereign state itself. The system of arbitration courts, which happen to be an integral part of the judicial system. That is a very interesting thing when KFCRI and the team had a good research, particularly the research done by Mr. Sippy Wist, Ms. Soundarya, Ms. Sakti Priya, Mr. Pranav, Mr. Devadathan, Mr. Kirti Vasan, and other prominent founding members of KFCRI. All the outcome ultimately found that it is all a constitutional right which has been given in the Kyrgyz jurisdiction. It also runs through several of these articles. There was another interesting article also for the good information for the Global South countries and the institutions as well as Global North institutions who are going to share their success story here. This jurisdiction of Kyrgyz Republic, the arbitration clause which was recommended in a chapter of the article itself, it quotes, for extrajudicial settlement of disputes arising from civil legal relations, citizens of Kyrgyz Republic are entitled to establish arbitration courts. Full stop. The order of establishment and functioning of arbitration courts shall be determined by law. It's a very unique clause, what we found. And this clearly gives the parties the right, when dealing with civil disputes, particularly emanating from a legal relationship, to establish arbitration courts. They are not mentioning about what the present day rule of law recommends about constituting arbitral tribunal. Here it is the parties creating the arbitration court. It's a very masterpiece, we can say, of promoting arbitration. But this, after the later stage, when the breakaway of the Soviet Union, however, had a different perspective. There are a lot of change happened. We, as the Global South countries, now looking into Kyrgyzstan, we are of the opinion that further development of arbitration in Kyrgyzstan should not be in expanding competencies of arbitral tribunal, which beyond the inherent functions they were designed for or contrary to the constitutional provision. It's a wonderful piece. The development, what's going to happen, I think the note given by the Ministry of Economy of Kyrgyzstan also had a comparative study wherein the existing mechanism, the new one which is likely to be brought in, is going to be quick. Why? Because it will allow disputes to be settled with recourse to a single legal authority with no possibility of appealing the decision. No doubt, like an ancestral model law, the development, the reforms, what's happening, it makes that Kyrgyzstan's arbitration would be more efficient, confidential, and will allow choice of applicable law, including place and language of the proceedings, all taken from the Article 7 of the ancestral model law for international commercial arbitration. It is also going to expand arbitrable disputes arising from states' exercise of its administrative functions, like even stretching to the level of tax and customs. Some developments which are happening, but still it should not be contrary to the constitutional provisions which has been well structured much earlier itself. Next step ahead should be in a Global South perspective, looking into Kyrgyzstan, even though it's a less studied jurisdiction or a country, The focus has to be on improving the cooperation between the judicial and the arbitration institutions or bodies. For the information to the participants, panelists, Ms. Begum was happy to share that the arbitration code, even now, which is titled as such, is the prominent arbitration body that is called the International Arbitration Code, attached to the Kyrgyz Chamber of Commerce and Industry. It is the arbitral body where the solution would be given for the parties in a one-stop manner. One way to achieve this, anyway, this would be to analyze the judicial practice, how the courts, as well as how Ms. Begum was mentioning about the AI's role. AI also is very, very rapidly developing. Not only all the Global South jurisdiction, Kyrgyzstan is one good example wherein there are abundant number of associations, as rightly pointed out in the last slide of Ms. Begum, particularly on the recommendation what she gave. It is going to support the arbitral bodies and thereafter providing trainings for judges based on the best international practice would give a proper clarifications of the disputes which emanates in that particular jurisdiction. As concluding remarks, hope I have not penetrated too much into the presentation of Ms. Begum on the AI part of Kyrgyzstan. As a better understanding from a legal practitioner's perspective, Kyrgyzstan, from its establishment, I think, if I'm not wrong, from 1993 to present day, the institutions of arbitration in Kyrgyzstan has gone through many changes. It has developed from being part of a judicial system into an institution of civil self-governance. That's what we look into from the Global South. However, the proposed changes by Kyrgyzstan government not only clashes the judicial system of the country based on the constitutional provisions as well as with arbitration, but also creates a high degree of certainty to some extent as far the institutional identity of the Institute of Arbitration in Kyrgyzstan. These are some points what I could derive from the AI tool which is being facilitated by Ms. Begum. Thank you, Ms. Begum, for spending your valuable time
Thank you.
sharing about AI in arbitration, particularly focusing Kyrgyzstan. Thank you.
Thank you.